And now we have in the studio Rommy, a legal practitioner, to speak more on the election tribunal's annulment of the Bielsa governorship election. Mr. Mom, glad to have you in our studio.
Glad to be here.
What is your take on the nullification of the election by the Bielsa Governorship Election Petition Tribunal?
Well, I think first and foremost, the court's idea to rule based on extant laws and regulations concerning our elections, and if the court has found as a fact that there was unlawful exclusion of a candidate and a party for that matter, it kind of restricts the choice of the electorate. The electorate is supposed to have the benefit of looking at every candidate that presents himself or herself and every party that is part of the elections. As when you shortchange the electorate as has been founded by the court, if that is what it is, then it's a natural and a consequential order of nullifying that election so that the electorate can have the benefit of looking at all the parties and all the candidates that are eligible for these elections, and from that decide on which candidate they would want to, govern them. Is there a right to be governed by who you want to? It's an extension of our rights as calculated in the Constitution and the electoral laws of this country.
Now, is it lawful for a political party to be excluded in an election?
No, certainly not, especially if that political party abides by the Electoral Act and the Constitution. Now, in this instance, the political party is saying, even though the initial candidate was ruled or was said not to be eligible via Section 177 of the Constitution because he wasn't of the age, they had substituted or had the ample chance to substitute a candidate. Their allegation again is that INEC did not take this into consideration and outrightly ruled them out of the contest. Now, if that is the case, as the court has found, by Section 33, 34, and 35 read collectively of the 2010 Electoral Act as amended, then it meant that they were unlawfully excluded. And if that is the case, then it is wrong, and the consequential order is the order for a new elections. But then again, we need to also look at what INEC is saying. INEC is saying that was not the case. And that was the minority decision of the chairman of the tribunal. He found as a fact that what happened could be said to be a pre-election matter, in which case it wasn't a matter for the tribunal, being that he was disqualified based on eligibility and not on exclusion. So it depends on what side of the coin you're looking at. But again, as we say, a judgment that is still standing and not yet overturned, then again, that's what it is. It's what the law is for now.
In all of this, where lies the right of the appeal?
Well, the court again had given the parties the right to appeal within the stipulated period. Appeal is it's a right. It's both constitutional and human because it goes down to fair hearing. If you say you are not satisfied, then you have the right to explore all the ambits of taking it to the higher quarters as the law permits. In this case, the Court of Appeal and the Supreme Court, as the governor has rightly said he wants to take it up to. I would think that it's important to appeal for two reasons. One, our jurisprudence will be expanded much more in decisions such as this, in looking at it going forward. And secondly, which is most important to me, and I think to all persons who are friends of the electoral space in Nigeria, the right of the voter, the citizen, will come to bear. All this is done in ensuring that the voice of the citizens is heard. It's not for us to, obfuscate that voice because of, things like technicalities and saying, let's exclude a candidate that is validly put forward by a political party.
Thank you very much for coming on the news, Mr. Mom.
You're welcome. Thank you.
That was Mr. Rommy, a legal practitioner, speaking on Bayelsa governorship election.